The dissolution procedure begins by one of the parties filing a petition for dissolution of marriage. This petition notifies the court that the parties are planning on ending their marriage. Most petitions are filed on the grounds of incompatibility. Incompatibility means that because of discord or conflict of personalities, the legitimate ends of the marriage relationship are destroyed, preventing any reasonable expectation of reconciliation. The petition alleges the ground for the dissolution, whether the parties have community assets and liabilities, whether they have separate assets and liabilities, whether they have minor children, and what form of custody the petitioner is requesting. And it sets out if spousal support or child support may be due from one party to the other. It can be filed by either party. Once filed, the other party is served with the petition. The other party has 30 days to respond to the petition. Usually discovery, interrogatories, which ask the recipient questions, and a request for production of documents, asking for documents, are exchanged. Sometimes a deposition, where one party is placed under oath and asked questions before a court reporter, takes place. Sometimes the process is informal, but more often formal, so that responses are under oath. In the meantime, how the parties are going to support themselves and service their assets and debts until the marriage is dissolved is at issue, because each party's earned income is community property. If the parties have separate income, let's say from a trust or retirement he or she had prior to the marriage, the trust might also divide the separate income. Each party fills out a worksheet that shows income, deductions, and what are called fixed expenses, such as a house payment, if one party moves out, his or her rent, utilities, insurance payments, car payments, minimum credit card payments, and other expenses. If there are minor children, an interim amount of child support is set based upon guidelines. Once the parties have sufficient information, the parties then start settlement negotiations aimed towards settling the matter. In many districts in New Mexico, there's mandatory mediation or facilitation. Sometimes counsel for the parties meet and see if agreements can be reached. If full settlement is reached, then the parties will sign a marital settlement agreement resolving their issues, and a final decree is prepared adopting those agreements for presentment to the court. If there are children issues, the resolution of those issues are set in what's called the parenting plan, which may be part of the agreement or they may be a separate document. The parenting plan will set out the form of custody, the decision-making responsibilities between the parents, must specify time sharing of the children between the parents, and address child support. The courts have to accept what the parties agree to as to their property, but they do not necessarily have to accept the parties' agreements as to custody or spousal or child support arrangements. Usually the parties' agreements to those areas are accepted if they're not impractical. If settlement negotiations do not conclude with a full agreement, then those items not agreed to will be set for a trial before a judge. Once the issues are resolved, a final decree of dissolution of marriage is issued.